Imagine this. You're standing in an airport. You just landed from an international flight. You're tired, you're ready to go home, and then a federal agent asks for your phone password. You give it to him, he types it in, and your phone goes blank. It restarts. Everything is gone. Factory reset, empty. Now the federal government wants to put you in prison, not for what was on your phone, but for what wasn't on it. Welcome to the first case in American history where the government has built a felony prosecution around a password. This is the story of Samuel Tunick, a U.S. citizen from Atlanta, and a case that could change how your rights work at the border. In this video, I'm breaking down what happened, why the government is prosecuting him, and what it means for your privacy. Before I break it down, hit that subscribe button and tap the bell. You do not want to be searching for this video after you've already handed over your phone at the airport. Let's start with the facts. On January 24th, 2025, Samuel Tunick landed at Hartsfield-Jackson Atlanta International Airport. He was coming home from an international trip. Customs and Border Protection pulled him aside for what's called a secondary inspection. That's the small room with the fluorescent lights and no good news. According to his defense filing, he asked for a lawyer repeatedly and didn't get one. He wasn't read his Miranda rights. And here's the line that should make every citizen sit up. The agents told him they didn't need a warrant to search his phone because he hadn't entered the United States yet. He was standing in Georgia. Georgia is a state. States are famously in America. But under the government's border theory, you're not legally here until they say you're here. The agents demanded his passcode. He gave them one. An agent typed it in. The screen went blank, flashed, and restarted. Whatever was on that phone was gone. The agents searched the phone anyway, and then this detail matters. They told him he was free to go. Welcome to America. Enjoy your stay. Here's where the case gets interesting. Tunick's phone was a Google Pixel running Graphene OS, a privacy-focused operating system. It has a documented feature called the duress PIN. The idea is simple. You set two codes. One unlocks your phone. The other one, if you're ever forced to hand over a code under coercion, wipes the device completely. It's a feature built for exactly one scenario, someone making you unlock your phone. The government's theory is that the passcode Tunick provided was the duress password. Tunick denies that. In fact, he denies setting up a duress passcode at all. That dispute is the entire case. For 10 months, nothing happened. Then, Tunick gets pulled over for a taillight issue. He steps out of the car, and it's not a traffic cop waiting for him. It's the FBI and Homeland Security with handcuffs. A federal grand jury indicted him on one count, knowingly destroying property to prevent the government from seizing it. Here's something you need to know about that indictment. It's one paragraph, and it misspells United States. The official court record says untied states, a document that can put a man in federal prison, and nobody ran spell check. Precision matters. Now let's put the lawyer hat on because this case has three separate constitutional fights packed into it. First, privacy at the border. In 2014, the Supreme Court said in Riley v. California that police need a warrant to search your phone. Your phone isn't just a container, it's your whole life. But there's an exception older than the Bill of Rights itself, the border search exception. And the courts are split on how far it stretches. The Ninth Circuit out west says warrantless border phone searches are limited. Agents can look for digital contraband, but they can't go on fishing expeditions. The 11th Circuit, where this case lives, says border agents don't need any suspicion at all. Not probable cause, not reasonable suspicion, nothing. So how much protection your phone has at the border depends on which airport you land at. That's not how the Constitution is supposed to work. Second, the statute. The government charged Tunick under a law that punishes destroying property to prevent the government from taking it. Here's my problem with that theory. The government already took the phone into custody. The physical property was seized on day one. What they didn't get was the data. So the courts are going to have to decide whether data is property under a statute written for physical evidence, and whether you can prevent a seizure that already happened. Then there's intent. The government has to prove Tunick knowingly destroyed the data to impair the seizure. He says he never set up a duress code. So how do you prove what a phone was configured to do when the thing you're upset about is that the phone no longer contains anything? The star witness is now a device with amnesia. Third, the Fifth Amendment. When the government forces you to hand over a passcode, is that compelled testimony? Producing a code reveals the contents of your mind. It admits the phone is yours, that you control it. Courts are all over the map on this. The 11th Circuit itself, back in 2012, held that forcing someone to decrypt a device can violate the Fifth Amendment. In Indiana, our Supreme Court held that compelling a woman to unlock her iPhone violated the Fifth Amendment. New Jersey's High Court went the other way. Some courts say your fingerprint isn't testimony, but your PIN number is. Same phone, same data, different constitutional universe. And the U.S. Supreme Court has repeatedly been asked to sort this out and has repeatedly said no. Now stack Tunick's facts on top of that mess. His lawyers say he was in custodial interrogation, no Miranda warnings. He asked for a lawyer and didn't get one. That's their account. If a judge agrees that the detention and the demand were unlawful, then everything that flowed from it, including the alleged wipe, could get suppressed. Lawyers call it the fruit of the poisonous tree. Without that fruit, this one-paragraph indictment might not have a second paragraph left to stand on. One more thing his lawyers say, and I'll flag it clearly as their allegation. They say the agents claim to be looking for child abuse material without any evidence supporting that suspicion, and that the real interest was Tunick's association with the movement protesting Atlanta's police training center. The government hasn't conceded any of that, and no court has ruled, but that's what suppression hearings are for, figuring out whether the stated reason for a search was the actual reason. Here's why this case matters to you. Even if your phone contains nothing but a grocery list and photos of your dog, this case affects you. The government asked a man a question. He answered it. And the government's position is that the answer was a crime. If that theory holds, ask yourself where it stops. Full disk encryption? The government can't break it. Is that preventing a seizure of your data? Disappearing messages? The remote wipe feature you're supposed to use when your phone gets stolen? Every one of those is a legitimate tool built by major companies, used by millions of people, that makes data unavailable to whoever's holding the device. A legal theory with no limiting principle isn't a theory. It's an appetite. Maybe the government proves its case. Maybe a jury hears evidence I haven't seen and finds intent beyond a reasonable doubt. That's how the system works, and I respect it. But a first-of-its-kind prosecution on a statute written for hiding physical evidence against a man the government's own paperwork couldn't spell United States for is something to watch closely. Here are the key takeaways from this case. First, your rights at the border are not settled. Depending on which circuit court you're in, your phone may or may not be protected. That's a problem that needs fixing. Second, the Fifth Amendment is still unresolved. Whether the government can compel you to hand over a password is an open question that the Supreme Court needs to answer. Third, the government's theory here is unprecedented. Prosecuting someone for what wasn't on their phone, because the phone wiped itself, is a dangerous legal stretch. Fourth, if you use encryption, if you use disappearing messages, if you use any tool that protects your data, pay attention to this case. The government's argument could apply to all of them. Fifth, always assert your rights. If you're detained at the border, ask for a lawyer. Invoke your right to remain silent. Do not assume that the agents are on your side. Practice these steps at home. Think about what you would say. When you're standing in an airport with a federal agent asking for your password, you don't want to think. You want your mouth to know what to say automatically. And remember, none of this is legal advice for your specific situation. Laws vary by state, and court interpretations can differ. If you're ever charged with a crime, consult a local attorney who knows the judges and prosecutors in your area. If this video helped you understand the constitutional issues in this case, hit that like button right now. Subscribe and ring the bell so you never miss an update. And drop a comment below. Would you have given up your password in that situation? I read every comment, and I will see you in the next video.